This Gruden story is weird because, one, I think it was described as like a major victory. The way I read it, it's just basically this Nevada Supreme Court said, hey, you can move ahead with this challenge, right?
Yes, but I do think it's a major victory.
Okay.
Because there's a lot of nuance here, but I'll start by saying the Nevada Supreme Court was interpreting California law and interpreting Gruden's employment contract, which was originated in Oakland, and the NFL Constitution, which was based in California and has California laws govern. So what they said, what the NFL was trying to do is say, Gruden, you're trying to sue Goodell and the NFL for tortious interference with the contract, his contract with the Raiders, and we can compel you to arbitration because your employment contract with the Raiders incorporates the NFL Constitution as it's required to. And in the NFL Constitution, all matters with members, their employees, and their players are arbitrated by the commissioner. And the Nevada Supreme Court came in and said, okay, hold on. Well, first off, the district court judge said, no, we don't think that applies. Gruden, you can move forward. NFL appealed to the Nevada Supreme Court. The Nevada Supreme Court looked at it and said this. Number one, the NFL Constitution obligation to arbitrate a case is only for current employees and players. He quit before he sued, and therefore it doesn't apply to him. But even if he was, this is the big part. We think that that provision is unconscionable and unenforceable because specifically the claims for Gruden were against Goodell, and Goodell cannot arbitrate any matters against him, nor can he be the person to determine who the quote-unquote neutral arbitrator is to arbitrate that dispute. So on basically three grounds, they threw out the NFL's argument. One, it doesn't apply to Gruden because he's a former employee. Two, Gruden didn't have a choice in to negotiate any part of this contract. The NFL requires all employee contracts to incorporate the NFL Constitution. The employment contract was 7 pages long. The NFL Constitution is 454 pages long. So he has no ability to negotiate any of those terms. It's mandatory. So it's what's known as a contract of adhesion. You either adhere to it or you reject it. And the courts don't look favorably upon those contracts. And then number three, Goodell can't be the master of the ceremonies in an action against him. He can't be the arbitrator. He can't choose the arbitrator. He can't choose the process. He can't do any of that stuff. And to allow him to do that is unconscionable. That's the big one because I think cleverly people in the future will make sure to name Goodell, get outside of an arbitration, file in a court,
right,
and say it's unconscionable.
Okay, what's the next step? Who's going to hear this?
Oh, now it goes back down to state court, and he moves forward with his case. Now, what's that mean? That means discovery. So Jon Gruden doesn't have the answer to where the emails came from and how they got leaked. And so somebody does, and that's what this whole discovery process is going to be about. Who knew what? Why was it released? What's the timing got to do with it? And what were their motivations, right? Was it really about, I mean, he needs the information for his claim to be successful to be out getting him fired or screwing the Raiders or both. He needs that to be the case. It can't just be somebody that says, hey, this was part of our investigation and that all needs to be public. And I am going to make sure that every little bit of this Washington, at the time, Redskins, investigation into Dan Snyder becomes public, and that just happened to be the first thing. That wouldn't be good enough, in my opinion, to be successful. It has to be that there was some motive against Gruden or against the Raiders, or both.
Could probably build a hell of a case if you wanted to go way back, all the way to Al Davis times.
That's right. I mean, you're going to.
I would love to see Camp Gruden roll in the awarding of the Rams to Kroenke and the Raiders not being awarded L.A.
100% they will do
I think
that.
there's a track record of league action against the Raiders, and now it's the Raiders coach.
Yep, no doubt.
This
no
is
doubt
all.
they'll do
By
it.
the way, this is also weird because while I root against the NFL as this behemoth, root against Goodell as judge, jury, and executioner, we're also now rooting for a guy who did throw out racial slurs, did call Goodell a gay slur, was sexist. I just
no doubt.
It's interesting
no doubt,
what you guys
but-
have to do as attorneys, where you have to compartmentalize, what was said versus what the case is, and the action that got this, these emails leaked. We're gonna.
But it's going to be impactful nonetheless because it gives a roadmap to some people who have maybe some legitimate concerns about what's going on with Gruden and the administration of the NFL's sort of justice. I contend that it's big enough now that that Goodell should not be in charge of discipline maybe at all, but certainly for conduct off the football field, because he's not qualified to do it. He never really was. He's a business guy, and it has taken them into a whole nother stratosphere of earnings, so he's never going to go anywhere. But this idea that he needs to retain this power for off-the-field conduct, I really just don't. I think it's a mistake. He's going to step into some potholes, and now some of those players are going to have some really good arguments to make, especially if he's the one who hands down the discipline, that it doesn't need to be arbitrated and they can go to court.
Brian Flores still doesn't have a head coaching gig.
Yep.
But he's very active in the NFL. I mean, he's with a good team and he's a DC with the Vikings. Is Gruden getting an NFL job again?
No. I don't think so. But I do think Flores' case is different because his dispute was really with his team. And Gruden had no problem with his team, and his team had no problem with him.
That's the league.
Right? The league put him in that situation where if you're Mark Davis, you're like, dude, I have to. Right? I have to. I'm not one of the big fish in here. I don't want them taking my team away. This is all I've got, so I have to. And that's why they entered into their own settlement agreement where Mark was able to take care of Gruden, provide him some financial stability, write in the settlement terms, waivers of claims that did not include waivers of claims against the NFL. In large part, what happened in the Supreme Court here was set up by Davis's and Gruden's relationship and Davis's willingness to work in the right kind of terms in that settlement.
I think if you talked, and I have no inside knowledge on this, I think if you talked to Mark Davis, he would probably say, I should have never done it. I should have never caved.
Right. I'm sure he would say that, but I'm sure he would do it again. Right? At that time, under those circumstances, with that move, and, they just taken a team basically away from Dan Snyder, is the offense as less damning. You talked about hey, remember we're sitting here talking about we hate the NFL, we're pro player, we're pro employee, but look at the conduct that we're defending here. I'm not defending the conduct. Right? I'm defending the idea that people's private conversations one-on-one are to be protected, and they shall not be used. There are laws against, and there's civil damages that get assessed when you take somebody's private conversation, you pull it out, and you publish it to the public in order to damage them. And that's exactly what Gruden is saying is done here. And if that was done, regardless of what was contained within the communication, then he's got a claim.
The allegation behind the scenes is that there was if I remember correctly, there was one wave of emails that were released and another one was coming. Mm-hmm. So they were holding. I mean, this is pretty strategic the way they did it.
Right. We have more damning emails out there.
The court.
Right. No, I agree. It's why if that's the case, then you have to assume the motivation by sending the first wave was to get him fired. Right? Why else would you hold back and not give it all out? If your idea behind it was we think the public should know what we found in this investigation, then so be it. But by only sending out some of the most, some damaging emails and saying, we got worse unless you do what we want, it proves Gruden's point. The purpose of the release was to get him fired.